Good afternoon, everyone. You are all welcome. My name is Geraldine Bunya. I'm a risk analyst at NITU. I welcome you to our third webinar that will focus on what you need to know about privacy engineering. This webinar is organized by the Uganda National Computer Emergency Response Team and Coordination Center, which is the focal point for incident handling at both national and international level. Before I invite our moderator for this session, just a few rules of engagement. Please send in your questions as the session progresses using the Q&A option at the bottom of your screen. With that, I'd like to introduce our moderator, Angela Tugume, who is the Manager Data Protection Affairs at the Personal Data Protection Office. Angela is a cybersecurity expert with over 15 years experience. She holds an MBA in information systems, is a certified information systems auditor, she's also certified in risk information systems control and certified information systems security professional, CISSP. Angela is also a fellow of the Africa Cyber Experts Fellowship. And as I mentioned earlier, she's working as the Manager Data Protection Affairs at the Personal Data Protection Office. And in this role, she supports the provision of relevant regulatory guidance, information and guidance to organizations and individuals in line with the Data Protection and Privacy Act 2019. Angela formerly worked as a risk analyst at NITA, where she was a key driver in driving effective risk management across government agencies. She is also the current president for the ISC2 Uganda chapter. ISC2 is an international and non-profit membership association for information security leaders whose vision is to inspire a safe and secure cyber world. With that, I would like to hand over to Angela. Thank you.
Thank you, Geraldine, for the kind introduction. I hope you can hear me. And I'd like to welcome our participants to today's webinar and say that we are excited to be having one of our guest speakers. And so today we'll be talking about privacy engineering, and we'll be highlighting privacy engineering and how it supports compliance with data protection regulations. Our speaker today will focus on key aspects of privacy in information systems, best practices on implementing privacy in information systems, how an organization should manage privacy-related risk in a digital world, achieving compliance with privacy laws in digitized processes. So we're going to look at the design, development, and implementation of information systems and how they should comply with the general principles of personal data protection and observe the right to privacy. Ladies and gentlemen, welcome with me as speaker today, Mr. Emmanuel Mugabi, who is an IT professional with over 12 years experience in the area of ICT, regulation, governance, advisory, cybersecurity, digital transformation, and privacy. Emmanuel is a certified data privacy solutions engineer, certified information security manager, certified information systems auditor, ISO 27001 senior lead implementer, and EC Council incident handler. He's also an active member of the ISACA Kampala chapter and ISC2 Kampala chapter. Thank you very much, Emmanuel. You're very welcome to today's talk. And I'll invite you to come and start us off with your presentation on privacy engineering. Thank you very much.
Thank you, Angela. Good afternoon, everyone, or good morning or good evening from wherever you're connecting. I'm happy to be here to talk about privacy engineering, which will do a large focus on the compliance with the data protection regulations, given that I see most people on the call are between Uganda and Kenya. So without further ado, I wanted to start with this to show the types of personal data, just to put it into context that we do collect from time to time on information systems. So anything that I can look at and identify a person and say this is who they are, then that becomes personal data. And this is just an example of past types of personal data. It's not in any way exhaustive. Things to do with names, phone numbers, date of birth, biometrics. Sensory data covers things to do with audio recordings or any CCTV video recordings, and also information related to financial, medical. Basically, if you have any of this or anything that relates to a person that you do collect as part of your business on an information system, then these are aspects that you need to know as you're planning the privacy engineering. So the context for today is, first of all, we do have an increase in volume and complexity of data due to, obviously, reliance on information systems. And this was further catalyzed by the COVID-19, which kind of forced everyone to take on a digital transformation agenda for the organization, be it a small and medium enterprise to medium enterprise to government and large scale enterprise. Everyone was forced to, in one way or another, use an internet-based system as part of their business. And that increased the volumes in types of data. Secondly, we know that data travels rapidly. For some people, a lot of people, they don't host their own servers, so they're going to rely on a data center somewhere to host their virtual servers. But also for others, they're going to use a platform or software as a service to be able to do their business. So you operate in Uganda, but your data is sitting somewhere in the US or Europe. So a lot of complexity comes in due to the different places in which within which data is hosted and processed. Because of that, obviously, there's less paper trail. So paper trails help to trace. You can easily trace how a file has moved. But in the digital world, that's not so clear, if not well designed, to achieve that audit trail. The other thing that we need to know that's in the mix is the Privacy Act and the regulations. These two pieces of legislation set new precedents that require businesses to account for personal data. And this is at every stage of processing, right from the time that you collect it up to the time that it goes to the cradle. Basically, the whole cycle, the whole life case use for personal data now requires compliance with the Personal Data Protection and Privacy Act. So this is the context for today. The principles in the acts are mainly this, and these are largely the same across other countries and even Europe, basically around accountability, fairness and lawfulness, adequacy of data, retention periods now have to be defined, quality of personal data has to be maintained so that it's reliable for the decision you're making and for the business, transparency, and also the appropriate security measures. So this is that list of principles that forms the basis when we start talking about privacy engineering that we have to know about. So when it comes to privacy engineering, this is how we start. I wanted to first put it out here so that we have an understanding of privacy engineering. Normally, people throw out one sentence that describes privacy engineering, but I'll take a different approach for this one and just give little bits of information that you can piece together and understand what privacy engineering is all about. One, this is a practice that relates to building the tools, the processes, procedures that help you to apply privacy protections to personal data. Remember the types of personal data that we talked about. Again, this is about embedding privacy into product development, whether you are developing this information system or product in-house using your own developers, or if you're outsourcing it, or if you're buying an already finished product that you're going to use, or a subscription that you're going to use. So this is all about getting these principles and making sure that they apply in whichever way you use them. The main purpose, again, is to make sure that you do achieve compliance within the design of whichever information system that you do have. And for most people that we've seen registering in the office and other cases that we've seen around, is people put out there what we call privacy policies or notices for their apps, for their systems, for their websites, but it's in a lot of so many words. Some of it is jargon-laden, and some of it has a lot of promises of things that they do, either don't do. So privacy engineering helps to bring to light, to actualization, whatever company says in their privacy policy or notice. Privacy engineering helps to bring that into actualization. When it comes to an IT system, how is that policy actually translated within there? Again, it ensures that you have in place the appropriate privacy controls throughout the life cycle of that system, because we change systems, versions are upgraded, some are retired, others are brought online. So the life cycle of that system has to make sure that it complies. So in totality, this helps to define and understand what privacy engineering is all about. Now, I wanted to bring this home, like Angela earlier mentioned, so that we can show how this relates to the data protection and privacy regulations for Uganda, for Uganda's case, because regulations prescribe certain things that you must know about. The Act has mainly the principles and the guidance and all that, but regulations go a little bit deeper with much more clear guidance for you as a data protection officer or as an organization, how you should comply. And privacy engineering is one way that you can help your organization to comply with the privacy regulations. So I'm just going to go through the key regulations and show how they link to privacy engineering. So the first regulation is on Regulation 10, which talks about collection and processing of personal data. And the implication for this is that for you as an organization, you are required to have in place knowledge from your IT teams, from development teams, the business dev teams, on the legal basis for collection of personal data. The law has about 6 areas. The first is consent, but consent is not the only one. There are other areas, if it's part of a contract, if it's part of a requirement prescribed by law, and different other areas. So it's important that as an organization, you understand which basis you're relying on, so that when you get to design that system, you know how best to achieve that on a web form. If your basis is going to be consent, then from the privacy engineering aspect, your web form, your mobile app, that information system has to have that provision to capture that consent. If it's not consent, then you can still know how to go about it. But it's important that the legal basis is clearly understood by the dev teams so that they can easily embed that in the design of how they collect this information in the actual instance. The second regulation that talks about, this one talks about children's personal data. This is from Regulation 11. And the law now says that if you're collecting personal data, you must make sure that you get consent of the guardian or the parent or whoever has authority over that child. And for a child is anyone below the age of 18, according to the Constitution of Uganda. So when this comes into an information system, if you're collecting this personal data of children, you have to make sure that within the design, you cater for capturing of consent of the parent or the guardian, because it is implied, what the law implies is that any decision at this stage on processing of personal data should be taken by someone who's an adult, because they understand the implications of providing such information to an organization. So if you're collecting personal data, then you need to make sure that you've embedded in by design that you're going to get consent from a parent or guardian. Number 2, this also entails you need to let people know within your terms and conditions, within your privacy notices, that the service you're providing is applicable to adults, so that they know, even from the word go, which kind of protects yourself along the way. The second aspect is on impact assessments. The law in Uganda's case says that you do have to do a data protection impact assessment if your processing of personal data is likely to be of high risk to your clients. And this mainly applies to where you're collecting special personal data. The law says this is data related to religious information, political opinions, sexual life, financial information, health status, or medical records of an individual. So if you're collecting this data as part of your business and you have it in your databases, in your information systems, the best practice is that you do a data protection impact assessment. This impact assessment should be done at the time that you're designing the terms of reference for this piece of software or for the platform that you're going to purchase, so that you know the risks and put in place the appropriate measures to protect that piece of personal data. And in Uganda's case, the law says you do this, but you don't have to bring it to the data protection office. You just have to make sure it is done and signed off. I see some colleagues here on the call from Kenya. In Kenya, it is different. You have to present this DPIA to the regulator for them to clear before you go ahead. So this is very important to help manage your risk where there's high risk, and especially the high risk comes with special personal data. So this is something that you do. Remember, privacy engineering is technical, but it's also procedure related. So this is one of those procedural rules that you can put in check as a best practice when looking at your information systems. The next regulation talks about the right now for data subjects to correct or delete personal data. Now a client has a right to send you a request and ask either to correct the personal data if that data is wrong, or if it has some issues, then as a client, they now have a right to request for that to be done. Number two, they can also ask to delete that data if they can prove that that processing of personal data is going to cause them harm or any other issue. Now, obviously, when it comes to you as an organization, it's very important as where possible to automate how you receive these requests from the subjects. The law gives you only 7 days within which to respond to such a request. But again, if it comes to updating of this information from the view of privacy engineering, if you have this data and it's sitting in different databases, then it becomes very hard to update someone's record. You might update it in one database and you find that in another database, it is still holding old data or the incorrect information. So it's important that you have well-optimized relational databases so that you can have a high level of normalization to know that when you update certain piece of data, then all the other stores within which it's stored can easily update, but also other dependent systems that rely on this data should be able to pick up from the updated data. Now, if this is not the case, it becomes very tedious and very hard to keep updating information, depending on the number of records that you have. If you have less than 100 records, then maybe you can work through that. If you have more than 1,000 records and you have so many requests coming in, it becomes quite a tedious effort to update this information. So it's important that you do have that in place to support these requests when they come in for correction of personal data. Because continuing to run data, yet I've sent a request to correct, it also becomes an issue for non-compliance with the law. The next regulation looks at data outside Uganda. Now, like we know, the cloud has brought about very many advantages, the largest being on cost effectiveness, but also efficiency. So for organizations, they look at the cost of having servers inside the organizations, you look at the cooling, the security controls around that, connectivity, uptime, power fluctuations, and you look at the cost of going to Google or Amazon. It makes business sense for you to go that route on to use a cloud provider. And also, when it comes to things with processing and compute, it's easy to expand, it's easy to burst according to your business demand. So from the technology perspective, we know that's a trend and it has its advantages. So from privacy engineering perspective, the law says whichever destination or country where you're hosting, it's up to you to do some bit of due diligence to make sure that that country has in place adequate measures for the protection of personal data. And for purposes of clarity, processing includes storage as well. So if you're storing data somewhere, then on an information system, that's also catered for under the term known as processing. Now, failure to comply with this attracts a fine of 2 currency points for each day that you're not compliant, or 3 months imprisonment, or both. And that's a decision that can be taken by courts of law. So it's important that you do your due diligence before getting a service, a cloud service. Make sure you check that that country has in place adequate measures. And also we're using a third party, because sometimes you've contracted someone else to do some piece of work for you or some compute. You have to make sure that you have done the due diligence to know where exactly this hosting of data, this processing of data is going to take place. Does that country have adequate measures in place in order to avoid these fines? And for those that have registered, you actually already filled in a Form 3 where you have committed that this is what you're doing. So it's important that you notice that and embed that as part of your privacy engineering. The next talks about security practices and procedures. Well, security and privacy are tightly related terms. So security focuses a lot on the confidentiality, integrity, and availability of the data. Privacy goes a little bit beyond that, like you've seen in the principles, things to do with quality of data, things to do with lawfulness, fairness, things to do with data minimization, which go beyond security. They go more into the things to do with privacy, where privacy engineering focuses on. But from time, the office will soon release procedures that you can look at and practices for information security that you can go and benchmark with and see how they're applicable to your organization. Now, obviously, there are different standards that exist for security, but security is not a focus for today. We're more on privacy engineering. But there are standards like the 27001, 27001 on privacy, PCI, and different others in OWASP that you can look at and you as an organization comply with. Now, where you can certify, this is a very good advantage to you because it shows that you've taken it to the highest level of maturity by exposing yourself to a global standard, which increases trust that you've done this right. Now, it's important that you maintain the records because this helps if things ever go wrong down the road. The next is look at data. We're using a contractor where to do your processing. Now, the law also requires that you check that that contractor also has adequate measures in there. And the best way of capturing that is within the contracts that you have. But you have to have a specific clause that requires the data processor to implement security, right? But also to report to you in case there's a breach, because liability here is different if a breach ever happens. So as part of your privacy engineering, it's important that you do that to protect the organization against any risk from a third party if they have a breach or if they have an issue with the personal data that they're collecting on their behalf. So again, due diligence is important to check that all your contractors, all your third parties, all your processors do have this in place before using the information system or before using their service. The next is about processing or collection of data without consent. This law applies retrospectively even to data that you're collecting even before the law came into force. So as long as you still have personal data now on your IT systems, you have to check and see the legal basis that you have for the current personal data that you have, and then align it to the findings. If you find you have personal data which you might have captured in all ways possible, even before the act came into force, and you're still relying on that data as part of the business processing, it's important that you do check that you have the legal basis right and make plans of action to comply if it's not. This also looks into things to do with retention periods for data. If I'm your customer for 1 month and I stop being your customer, do you still have to hold my data even after I have left or no longer use the service? So these are things that you embed within the logic when you talk about privacy engineering, so that you can know when to retire certain data or how long to retain the information that you have. If consent is one that you're relying on, then make sure that it's properly designed within the information systems and the apps. Now, under the rights, the regulations, services have a right to access personal information. So right now, any client can ask to you and say, please give me whatever information you have about me, and you have to respond. Now, since you have this data on information systems, it's important that you first verify that the person requesting is actually, first of all, your customer or your client, and number two, you confirm the identity before responding, because normally you want to respond to it mainly via email. So in this day and age, it's very easy for me to create an email, even when I'm not that person. I can create a false identity and then send a request to a certain organization, request for data for someone else. Now, if the organization is careless enough, then they might give that information to a wrong person, which will now cause a breach by themselves. So from the design perspective, it's important that such requests are validated to confirm the identity of the person requesting before responding to give them the information that you're asking for. Then there's the right to prevent processing of data beyond the purpose for which it was collected. So if you're a business that's collecting information to provide, let's say, a certain service to your clients, along the way you have a new service and you want to use that same information. If the purpose is very different from the original one, then you do have to go back and get consent or inform your subjects. So when you bring on board new services, new platform, new systems, and new innovative ways of using data, if it is beyond the original purpose, then you have to embed that there so that you make sure that you're always aligned to what the law asks, and also the transparency to your clients. This one is quite interesting on direct marketing from Regulation 37. Right now, clients have a right for you to stop processing their personal data if that data is being used for direct marketing. So when you're designing your customer onboarding journey, I've seen a lot of people doing this on websites. We're talking about e-banking now. A lot of companies banks are now pushing as well e-banking, e-commerce companies. Basically, anyone who's using a web form or website or a mobile app, this is to do business, and people have to create an account on that platform and to access that service. So we've normally seen marketing mixed with the purpose of the business. And these are two separate things that you need to know from the design perspective. I can be your client, and I don't want to receive updates, promotions, coupons, new sales for different seasons, Easter, Ramadan, and all that, Christmas. I can be a client, and I don't want that type of marketing. But for what we've seen around, for most people, they bundle this and say, as long as you sign up for this service, this is our privacy notice, we are going to use your personal data to send you a BCDF. But the law says someone has a right to stop when that happens. They have a right to stop direct marketing. So from the design perspective, it's important that you allow your customers to opt in by default. So ideally, your form should have a section that says, if you want to receive updates from us on new products, new services, seasonal campaigns, please consent here, so that someone can opt in and consent to receive that direct marketing. Otherwise, from the engineering perspective, it shouldn't be assumed that I want to receive this marketing. So it's important that those two are not bundled together and be separated for the mobile apps and even for the websites that we do run, different organizations. Now, when it comes to automated decision-making, if you're using, this only applies to decisions which are taken in a purely automated manner without human intervention. So using a little bit of artificial intelligence or using data science to take a decision on a customer, either to see what service they want or what loan they qualify for, or how to handle their requests. If this is being done in a purely automated manner without human intervention, then the rights of the subjects can now come and say, I want to review that decision that was taken. So from a privacy engineering perspective, when you're designing your IT system or you're using AI or data science for purely automated decision-making, now you have to put in an option for human intervention so that when a client asks, you're able to get a human being to review that decision that was taken by AI or data science so that the outcome, the person can have comfort that someone has looked at that decision. This is mainly to avoid things to do with discrimination, this to do with bias, then some unfairness that sometimes come as a result of using a little bit of automated decision-making to tell how to treat someone. So it's important that from the design of these systems, the requirements design, where automated decision is going to be used, then there has to be a chance that someone can ask for human intervention to review such a decision. And there's case law on this, people that have been sued on these different areas. Now, for just a little bit guidance on using AI is you make sure that at all stages of that AI life cycle, from its design to its operation, that there's respect for human rights and also their fundamental freedoms, and also the acquisition of personal data, its storage, how it's accessed, should also make sure that they comply with the general principles that we had earlier talked about. Now, towards the end of regulations, the office has powers to investigate complaints. So a customer or a data subject can come and complain to you if they think that you are misusing their data, or if you're not responding to their requests that they do send. Like I mentioned, some have 7 days for you to respond. Most of them have an average of 7 days. So if someone makes a request and 7 days elapse, they have a right, they can go to the office and make these complaints, or they can even go directly to the office to make the complaint. But the office, on receiving these complaints, they have so many powers to investigate these complaints. So if the office writes to you as a company, and that complaint has data which is on an information system, then the office has all powers to review that system. So on your side, from privacy engineering, you have to make sure that you do have proper audit controls, you have audit trails, that all the systems that the controls you have are actually working. Because when the audit, if such a complaint comes, or if an audit comes from the office and asks for this information, if it's not there, then that's not a good story. You don't want to appear very shady where you can't provide information that's being required from an information system. So it's important you maintain these trails and maintain the standard operating procedures, how you can provide access to an external auditor or to an investigator who would like to come and probe and review records to ascertain or to respond to a complaint. So this is very important when it comes to the engineering for your platforms. The next part that relates to that is preservation of information during investigation. Now, when it comes to IT systems, we know the data is volatile. You can receive a complaint now, or let's say if it is a breach or a misuse of data, and an organization realizes that they are going to be in deep trouble. So for some, they will go and quickly delete their data, or intentionally crash the servers, or some action that is going to kill that piece of evidence. So now, in such cases, the office has powers to go through court and ask for an order to preserve information. So before they even come to investigate, they go to court, obtain the order, and you get a request to preserve information on your information system. Now, how does that reflect to you when it comes to your privacy engineering? How have you catered for that to preserve information? Especially where it's on the cloud, or if you're using a third party, you need to have procedures now that allow you to easily respond to that. Otherwise, if this request comes from court and the regulator comes and this information wasn't preserved, or if it was altered or deleted, then again, you don't want to appear shady in such a case. So it's important from privacy engineering that you do have in place these SOPs to preserve this information on an information system once the request comes in from the office. Now, this is just a high level from NIST about a privacy engineering framework for information systems. This goes to the life cycle for information systems. So right from the time you do the concept to the time that you do operational maintenance, there are different stages within which you do the checks for privacy engineering to make sure that the requirements are done at the architecture level right before you go to development and integration with any third parties, doing the tests and also doing that transition. So this is the normal life cycle that just shows at which points privacy engineering is required to make sure that the requirements are catered for. Now, in the beginning, remember, I said information security focus mainly on confidentiality, integrity, and availability. Now, privacy engineering looks at the other things to do with fairness, lawfulness, quality, transparency, and it also has three main building blocks, as we've seen from the previous slides. So the first is predictability, second is manageability, and the third objective is this associability. So predictability is more of making sure that you've enabled reliable assumptions for your clients. You as a controller, you have obligations when it comes to personal data, and also the processes that you're using. You also have checks that you have to do to make sure that privacy data, so that personal data is protected where the information system is involved, like we've seen. The second, manageability, now looks at those granular things that have to be done on the information system. What are rotation periods that are there, who has access to it, if the requests come in to update this information, how is that easily done? If it comes to its deletion, what are the controls around that? So the things to do with consent, how is consent done? How is it obtained? The questions that you're hosting this. So this granular administration comes more on the manageability aspect. Now, this associability looks at when it comes to producing information for research, statistical reporting, analysis that you do. Some companies use funnels, marketing funnels to group their different customers according to patterns, behaviors, and all that. So when it comes to some of these things, it's important to use things to do with the identification of personal data, because you can easily get your customer database and de-identify, remove all parts of personal data and give that to a marketing person for them to develop a funnel for you, saying maybe 10% of your customers are coming in using an Android phone, 10% are using an iPhone. That type of information that can help you do your marketing, but without saying exactly the name of the client or the identity of the client that you're using for your analysis or your data aggregation. So it's important. That's where this associability comes in, to make sure that you de-identify personal data, so that there's no association to an individual or the devices that are using beyond the operational requirements for an information system. So these are the main three things that we've arrived at when it comes to privacy engineering that you need to take into consideration. So again, now mapping this to the principles that we earlier saw, when it comes to accountability, this is where you have to be accountable to the notices you give and all that. Then this mainly relates to predictability, manageability, disassociability, fairness and lawfulness. This means that the data you're collecting is lawful, that if it's consent, you have paid for consent. If it's not consent, is it a contract that you're basically going to collect this data? If it's not a contract, is it a requirement of the law? Like we know some sectors like financial sector, they're required to do KYC. That could be a basis for collecting data. So predictability helps to do that. Adequacy, that principle looked at looks mainly at making sure that the data that you have is just enough for you to offer someone a service. So a while ago, I saw someone posting, one of these restaurants which has a mobile app, and somewhere along the way, they wanted you to give your date of birth or whatever. So for them, their design was to make sure they can use that to give you promotions or whatever, if you happen to make an order on your birthday. But it's not important for me if I want to get a service, whether I know my birthday or not. So that's because a little bit, that information is more than necessary for me to order for food, order for a drink. So adequacy, now we're looking at manageability and accessibility, retention. Again, some sectors that are heavily regulated, like finance, do have areas where they have a minimum period of 10 years for which you have to retain data for your transactions and related KYC information. Others don't have that. So retention, that's one. Manageability, quality of the data, allowing your clients to update when they need to update on your information system. If I want to change my details, or if there's an error that I need to correct, then that's on the quality of the data. And transparency also comes in on how you manage the entire ecosystem. So this kind of brings us to wrap up, to show the principles we started with and how they relate to these three objectives of privacy engineering. Now, again, for privacy engineering, this is at the nexus of legal, policy, engineering, and the products that we do have in place. So I thank you so much for listening. This brings me to the end of my presentation. I do run a blog where you can check on for any updates that will be coming out. Thank you so much. Back to you, Angela.
Thank you so much, Emmanuel. Ladies and gentlemen, this is the point at which we get to the Q&A. If you do have any questions, please drop them in the Q&A section of this webinar, and we'll be more than happy to respond to them. Emmanuel, there is a question in the Q&A that I will just pull up right now, and it's the question is, why is it that some data collectors make it mandatory to opt in when registering for events, webinars, conferences, etc.? When you choose not to opt in, the registration process ends. And I have experienced this on numerous occasions. Emmanuel, over to you.
Thank you for the question. Yes, so in this case, the organizer of the event, according to the law, they are the data controller. So when they're using a web form for people to register, there's what they call, in the regulations, there's something that is called legitimate interest. It is a quiet term in there that you can use to collect some information, where the person you're collecting it from reasonably expects that you're going to collect that. So for example, give an example, if I walk into a hotel, I know that the CCTV at the entrance, and they're recording. So that CCTV obviously has your likeliness, it has your face and all that, because it's a hotel and it's part of their security measures. So I kind of expect it to happen there. So there's a bit of legitimate interest because of security and all that. So it comes to an event, a person organizing an event. For most events that you go to, you as a person attending, you do have a reasonable expectation that you're going to register. And you're going to register, for most people, it's a phone number and either your name, phone number, email address. So there's a bit of legitimate interest because someone wants to know and identify who's coming to their event. So for some, they do that, especially if it's online. Legitimate interest is also to avoid bots coming in, Zoom bombing for people to come in to such events. So there's a bit of legitimate interest that the event organizer can rely on and design that on their form when it comes to privacy engineering to say, hey, we just need to identify who's coming to the event. Just let us know your name, your phone number, email address, organization you work for. So that's information that you can even find on a business card or somewhere. It's not so damaging. But if the event organizer is going ahead to ask for more information, medical data and all those things, then that's not adequate for the event that they're organizing for. And also it's important for them to let you know that I'm going to use this information just to register you for this event. But after this event, I will do away with it maybe after 2 or 3 days or whatever. So from there, they can rely on legitimate interest to do that, because they, even as when you're attending an event, you reasonably expect that you register. Like this webinar today, there was a request to register. So you felt people had to go and fill in a form and click register. So there's a bit of engineering embedded in that form to know who is coming and also to avoid bots, people do Zoom bombing to attend the event.
Thank you very much, Emmanuel. Brian, I hope your question was answered. If not, you can put a follow-up question in the Q&A. Robert does also mention that the interest is also for accountability for organizations that hold conferences and things of the like. Accountability also comes into play. Now, Emmanuel, our next question is from Arthur, and it says, we have a lot of apps that are collecting a lot of our personal data. You can't use some features without allowing permissions. How can we go about this? And what is NITAU doing to ensure data protection laws are followed? Thank you. Emmanuel, over to you. Maybe I'll read the second question and you can take them at a go. Technology terms are complex to understand. This is from Sarah, especially for basic end users. How can these issues be communicated to end users so that they are able to meaningfully participate and contribute to privacy engineering processes? Emmanuel, over to you.
Thank you so for the questions. Yes, mobile apps is a very good question because everyone is now churning out a mobile app for some way or another. And some of these mobile apps, if you investigate them, you're going to find that they are collecting quite a lot of information. You might want to, you're just for a service to, let's say, order for food or something, but you find the mobile app, the person is actually harvesting a lot of information. One, they take your entire phone book, access to your gallery, access to your messages, access to your location, access to know which other apps of other competitors that you're running on your smartphone. If you have a banking app, that can help to profile the type of spend that you have. So different things that there's a lot of information that someone can obtain through a mobile app, from the permissions that are designed from the developer of that app. Now, it's important that for organizations that have these apps do manage their risk to make sure that they only have, again, it goes back to privacy engineering, when it goes back to manageability and predictability, to make sure they are collecting information only for what is necessary for them to give a service. Where can you go if someone is doing this without your consent? We do have the Personal Data Protection Office. Good enough, our moderator today will tell us more about what the Personal Data Protection Office is doing to ensure those laws are followed. Just a small clarity is that the entity mandated to enforce the law is not NITA Uganda. It's the Personal Data Protection Office, where Angela, I think, will give clarity on that. Yes, some of these technology terms are very complex, and we have a duty to make sure that we make them as simple as possible, given that a lot of people are coming face to face with this from last year, this year. It's still quite new. A lot of people are still getting to grips with this. So we should be seeing a lot of community effort around making these terms simpler, with more awareness, with citizens to know what their rights are, and also business leaders to know what they have to do in order to make sure that at the end of the day, the privacy of citizens is observed. Angela, do you want to clarify on the office?
Oh, yes, Emma, thank you very much for answering the question. Yes, to Arthur, yes, the Personal Data Protection Office is responsible for regulating and enforcing the Data Protection and Privacy Act of 2019 in Uganda. Now, what are some of the things that we are doing to make sure that these laws are followed? Number one is to know that for every data processor and controller, one of the requirements is for them to register with the office. And then the other requirement is for the office, where we conduct compliance audits to make sure that various data processors are actually complying with the law, with the act. Now, it's important that when we talk about compliance, we look at one of the key principles in privacy is the principle of minimality, collecting as little information as you need to get to the process where you do the work or where you offer that service. So one of the things that we look out for when we're registering entities or even doing our compliance audits is to find out how are these organizations implementing the principles of data protection and privacy. And in your case, a minimality is that principle that we look out for. How are you making sure that your apps, your systems, your applications don't actually collect more information, more data than they require? So it's an ongoing process, but those are the key things that we require from entities that collect data. And then the other key thing that we do is create awareness for our end users, the data subjects, and also for the entities that collect data. Now, once awareness is created, then we have the data subjects or the users or the people whose information is collected being aware of their rights under this law. And once you're aware of your right under this law, that means that you can actually lodge the complaint with that organization or with the Personal Data Protection Office, and we'll be able to launch an investigation and make sure that these companies begin then to comply with this law. So I hope that answers your question. Then we have another question, Emmanuel, that talks about nowadays, many people take pictures and put them on many online platforms such as Twitter, Facebook, TikTok, Instagram, Pinterest, and many others without knowing that these photos, pictures contain a lot of information about the people. Is there any laws that can help the people protect that info? And can we help these know how to get info of these photos before uploading them? Emma, over to you. I think this is more of in terms of geodata that comes up with most of the pictures that are uploaded. And maybe one other question, so that you take them at once. Personal data is a valuable commodity, so much that many times it is a transaction. Give me your data for access to a PDF, a game, an app, a feature, etc. How do we balance this reality with the need for privacy and online safety? Emmanuel, over to you.
Thank you so much. Yes, if someone takes a photo, that's again falls under the types of personal data, and you do have a right. Yes, if there's a law, the question is yes. The Personal Data Protection Act provides you a right for you to request the person to take down that photo since they have not gotten your consent or you are not part of that activity. So the law, as a person, if that happens to you, you have a right to immediately write that person and ask them to stop using your photo because they didn't get your consent. And also you can also make a complaint with the office to help you execute that. Though there are some ways within which that has different circumstances. So if it's, let's say, journalistic work and it's part of public interest, or if you're a public person, like a minister or someone where it's reasonably expected that that photo is in public interest, then somewhere those don't apply. But if it's you as a data subject, a citizen, and someone is using your photo in a way that makes it uncomfortable or that you don't agree with, then you can write that person and ask them to take it down. And we've helped so many people in the past to achieve that under the Data Protection and Privacy Act, even from some blogs and all that. It has actually happened where we've asked people to take down and they have complied with the requests of those that have been affected. So this actually requires more awareness, and also see this in the media a lot. For example, as you've said, there was an accident for the Link bus, which claimed over 20 lives on the Fort Portal Kamanji Express Highway. So you see most of the media houses took time to publish photos that did not show the image of those that were involved. But then we've seen things to do with citizen journalism, someone just posting the entire thing as it is, people in distress, which is not good when use of people's photos and video in such cases, because they're in distress, first of all. Number two, that affects them. It can even affect psychologically their families who get to know such things by seeing photo without anything informed or in advance. So it's a journey that the office is working to make sure that more awareness goes out to the public so that they know how to exercise their right. Now, on personal data being as a valuable commodity, this is a very unfortunate experience. Yesterday, I was engaging with someone and I had to get a report from the website. But for me to get the report, I had to fill in so many things just to download the report of their website. So it was more of an exchange. Give us your data and we give you the report, which was unnecessary. So for this, again, it's a continuous practice, security and cycle of awareness and engagements with different parts of the public, providers, organizations that they know their rights, they know their obligations. We'll get there. We've started and we'll get many people on board to be able to achieve that same level of understanding, to avoid that trap of exchanging personal data in order to get a commodity. Arthur, on how data can get you more involved in ensuring that insights on cybersecurity development of easy content for users. Oh yes, I think this relates to the question from Sarah on how we can make this information easier for people to understand. And this is an offer from Arthur from Accra University to collaborate on such. Thank you so much, Arthur. We'll be getting in touch after this webinar, definitely to see how we can simplify the language.
Okay, thank you so much, Emmanuel. And Arthur, the PDP office will also be getting in touch, or you can just drop us an email at info@pdpo.go.ug. We'd like to collaborate and partner with as many players and as many sectors as we can. Ladies and gentlemen, we have come to the top of the hour. Thank you so much for being with us on this webinar. I would like to ask Emmanuel to give us a closing remark if he has any, and then I'll hand it over to our hosts.
Mine is to thank everyone who has turned up for making the time, the 1 hour off a busy schedule to listen in on this. And I do hope it was insightful. We'll do share this information, the presentations that you can do your own walkthrough. And a call to everyone, if you're a data protection officer, if you're in an organization, please make sure that you do adopt privacy engineering, which saves you a lot of headache, saves you a lot of risks. But at the end of the day, someone sent a tweet before this and they were saying it helps remove the friction between your users and also the organization. Thank you so much.
And yes, thank you so much, Emmanuel, for taking us through this emerging field of privacy engineering, on how we can actually proactively embed privacy by design in our systems and our processes and our procedures. So once again, from us to the participants on the call, we appreciate your time and would also like to keep in touch. Remember to follow NITA Uganda on LinkedIn, on Twitter, at PDPOUG on LinkedIn, and Personal Data Protection Office on LinkedIn, and National IT Authority on LinkedIn for NITA Uganda. Thank you very much. Geraldine, I'd like to hand over back to you.
Okay. Thank you so much. On behalf of NITA and the National SAT and Coordination Center, I just want to say thank you so much to Angela for moderating this session, and also accepting our invitation to moderate. And then to Emma, thank you for sharing your insights and sharing your insights and knowledge about privacy engineering. And to the participants, thank you again for taking that time to attend this webinar. Please note that we'll be having the next one, which will be our 4th webinar. It will be about how blockchain can be leveraged in e-service delivery. It will happen same time next week on Thursday. starting at 2 p.m. So please continue following our social media channels. And also, if you had already signed up for this webinar or the previous webinar, please, we'll also send you an update for this new, for the upcoming webinar. Thank you very much and have a good day.